afternoon, Supreme Court. Natasha speaking.
Hi, Natasha. It's Shivesh.
How are you?
I'm well. How are you?
Yeah, good, thank you.
I was calling about the response that I sent to the solicitor acting for the court, Victorian, in regard to my Freedom of Information application.
Okay.
I'm not sure whether you've had any further discussions with anybody about that, but
no, I haven't, to be honest. All I know is it's gone to the Prothonotary and a few other for your Freedom of Information request, and I don't know the current status of it though at this stage.
Okay. One other matter that I wanted to confirm with you, or the court rather, is that I understand that the court is required to respond to my request within a certain number of days, and in the correspondence, so I thought the correspondence was meant to discourage an application for an application pursuant to the right set out in the Freedom of Information Act, and among other things, it claimed that the application had not been made because the fee had not been paid. Now, I understand that that's not technically the position in that.
Sorry, I'm not following. Sorry, say again. I got a bit lost there.
Okay.
Start again with that, sorry.
All right. So, you know that there's a federal Freedom of Information Act and the state Freedom of Information Act. In the federal, did you say no?
Well, no, I don't really keep up to date with all of those, but yeah, go on.
So there's a federal Freedom of Information Act and a state one. In the federal act, there is a centralized agency that's responsible for the production of the documents that are sought. So you don't have to contact the particular government agency.
They contact them for you and collate it all for you.
It's a more streamlined process, and there are dedicated officers that just do that, so you don't have to deal with the agency. And then also there's the issues around whether or not it's appropriate for the agency to discover the evidence sought. They're also sort of mediated better, whereas in the state legislation you have to contact the specific agency.
Okay, yep.
And the other problem with that is with the central process, there's one application process or one point of contact, whereas with the state one, you have to identify who in the particular agency is the responsible party, and then also different agencies may have different processes sometimes. And the information is not clearly laid out all the time on websites or whatever. Now, one issue with the applications for applications that seek information pursuant to the Freedom of Information Act is the payment of the fee. I know that the courts have previously held that the payment of the fee is a necessary component of successful application. So it's a nominal fee, but still this held that if the fee was not paid, then the agency is within its right to reject the production of the
That's normal, yes.
Yeah. So
that's normal, yes.
It's like a $30 fee, but anyway. The issue is that the bank details or the payment details are not advertised on the websites of the specific agency. So, for instance, Court Victoria does not advertise, or at least it's not clearly specified anywhere what the payment method is for that particular thing. So, when I made the application pursuant to the Freedom of Information Act to the Supreme Court, the normal process is for the court to write to me and say that these are the payment details. Can you pay, and then we can process the application. But the application is taken to have been made on the date that it was made, not on the date the fee is paid. But unless the fee is paid, you will not produce the documents. That's the rule. Whereas the communication from the lawyer, which I thought was misrepresentative on a number of levels, among other things, it seemed to claim that the orders, the orders of the Prothonotary were judicial in nature. But the relevant part of the communication, which I wish to get some clarity on, is the representation that the application had not been validly made earlier because the fee had not been paid. Now, I could not have paid the fee because I didn't know what
you didn't have the details.
That's right. So I've previously applied to other agencies, including the LSC, and the normal process is for them to get back to you promptly and then give you the bank details, so then you make the payment. They can also express a view about whether or not they think your application will be successful and so on, but generally the response is fairly quick, and then you get the bank details. In the court case, the response was fairly delayed. I mean, it was like 4 weeks off or something like that. Now that's relevant because I think the production of documents has to happen within a certain number of days. I can't remember exactly what it is, but I would have thought it was 28 days or 42 days, something like that. But it's not. Yeah,
28 days rings a bell with me, but I can't confirm that.
Yeah. So the problem that we have is I wasn't given bank details, and if there's a disagreement, I'll have to look up the legislation and then consider what the. But my initial understanding is that my 28 days started when I first made the request. And within 28 days of that, the court was required to provide the documents and also payment details so I could timely make the payment. But the response itself came fairly delayed, and it seemed to indicate that I hadn't made a valid application because I hadn't paid the fee. So, yeah. And I mean...
Okay, so you've got I've only got bits and pieces of emails, to be honest, Shavesh, regarding this. So I've got the one in which you respond to a Miss Emily Sandarusi regarding her correspondence, and then your reply back also with your payment. Have you had a response back from them again?
No, that's what I'm calling you.
Okay, so that was sent to CSB, and that was sent on. Was that sent directly to Emily, or it wasn't? No. It was just supplied back to Freedom of Information, of course, by the look of it. Okay, let me just see what
I didn't have her direct email address. Oh, okay.
Sorry, say again? Yeah, you only responded straight back to Freedom of Information at court, and not to her, and then to us and Lulu.
Yeah, but in her letter she had said that is the email address I need to use.
Yeah, no, that's fine. No, that's fine. Okay.
And she said I should copy you in. So.
Yeah, no, that's fine. Can I put on hold for a moment, please?
Yeah. Yeah. Can you ask her to start working the exhibit cover first? What? No, you two will work with the talk to each other.
Are you there?
Yeah.
Yep. No, I have no answer for you today, but I will follow that up. I've received nothing back as well, so I'll follow that up today and see if I can have an answer for you and give you a call back either this afternoon or tomorrow, hopefully with some sort of information regarding that.
Yeah, because at this stage, I will check the legislation, but I think the court has exceeded the deadline set out in the legislation, and I just wanted to speak with you first before checking what recourse is. The second... Sorry.
Yeah, no worries. Okay, no worries. I'll follow that one up. I'll put that on my list, and I'll see what information I can find for you. Okay.
Yeah. Also, there's another matter which is equally complicated, if not more, and I'm sorry about that in advance. We're at the moment in the process of appealing the orders of J. Forbes, and one of the issues that is raised is the fact that Her Honor, in our view, deliberately did not accept the applications that were made in the practice court, and that materially disadvantaged us. Now, I've done some research in this, and technically the rejection of the application was made by the practice court coordinator. One could not say that it was a judicial order, because I understand that they would have acted on the instructions of the judge, but it was actually the decision of the practice court coordinator, because constitutionally it cannot be the decision of a judge, because there was no hearing, and that's not how judicial decisions are made. So it will not be recognized as a judicial decision. It's the decision of the coordinator, and it has been communicated by the coordinator for that formal purpose. There were a few problems with the decision, and there's complaints about procedural fairness, which I understand are more difficult to decide, but I think there's a breach of technical rules as well, which is that one of the applications was rejected on the basis that the court had no jurisdiction to hear a matter regarding the refusal to renew the practicing certificate of Mr. Ansel, because the appeals to those who laid to VCAT. That's not actually right. We weren't making an appeal. We were seeking to judicially review the decision. And you can judicially review the decision, any decision of any administrator. That's not an appeal. In fact, there's a provision in the Uniform Law which specifically says that nothing in the provisions can impede the court's ability to judicially review the decision. So we weren't asking for it wasn't an appeal, it was a judicial. So to give you an example, I have right now raised a judicial review of the interim order that was made in a proceeding in the family court of the magistrates court. Under the legislation, there can be no appeal to the interim order in that sort of a proceeding.
So you're reviewed it instead, yes?
Yes. So it's a family safety notice, something bullshit. But you can only make appeals. Sorry?
No, it's okay, keep going. You only make an appeal on a final decision. So yes, you've done a review since the interim. Yep.
Yeah. So basically there was an error in the rejection of the application, which was it's a very discreet and direct breach of what the legal principle is in that respect, and so someone's made an error. Our view is that it has to be the administrative part of the court because there was no hearing. And what I need to know is who would be the right party to add in the proceedings. Would it be the Prothonotary or would it be the office? Is there an office of the practice court coordinator or is it just the Prothonotary?
No, the Prothonotary is obviously the main function of the head of the principal registry. So their decision, ultimately they're the person who makes all the decisions and everyone else is below him like a deputy, as we've discussed before in the past, that have been appointed as deputies. Whether it comes to the role at the practice court, that role obviously has its own, I don't think the word I'm thinking of, position description. So they have functions in which they're required to provide as that position, but they report to the Prothonotary. So it'd be up to you whether you want to name that person directly or whether you just want to name the Prothonotary. Obviously, if you were to file it and it worked out to be the wrong person, it could always be amended to the correct person, but it'll be up to you whether in which avenue you would like to name. I can't tell you, but I can only tell you the hierarchy and how everyone sits in the court.
Okay, so I think the first question is whether the legislation permits an individual to have accountability for their decisions. So, for instance, you couldn't sue a police officer in their own name because the Victorian Police Act essentially sets out the process of suing police officers, and that you sue the state, and then if the state decides whether or not their actions were legitimately carried out in the performance of their duty. If they're not, then basically they tell you that you can sue the individual. Otherwise, it's the state and you continue to sue the state. I'm not familiar with anything in the Supreme Court Act which says that you can't sue individuals, but I think this would not be, we're not so much alleging that there's malicious conduct. It's an error in the performance of the duty. So that would normally be under the position rather than, a personal suit against a person or whatever. So I think it has to be a position, but rather than a name. It's really the act that should clarify who the entity is. So I think the Supreme.
Well, you would just need to be 100% sure under the Supreme Court Act. Obviously, it wouldn't be under the rules, but whether under the Supreme Court Act, if you can actually make that application against a person.
No, so you can sue anybody who's not immune. So
That's right. So you need to check the Supreme Court Act to make sure that they're not immune to that.
Yeah, no, only judges have limited immunity. Nobody else in the form of government that we have here has immunity for their actions. And also the actions when they're not judicial, there's no immunity that comes from them. So there's no immunity for the actions of court administrative staff. Okay, I was hoping that there'd be a practice note or something about it.
No, there wouldn't be, because this is, I've actually never heard of anyone doing this, I'll be honest with you, I've never heard of anyone doing this. So normally once a decision is made by anyone in the court, most people just move on to the next thing and don't try to judicially review a decision like that. So there obviously wouldn't be any practice note that would have regarding that. So it'd be up to you whether who you want to name and whether that'd be the correct person. You just need to, as I said, make sure that they don't fall under whether they're immune or not. I'll be making sure you read Section 106 of the Supreme Court Act to make sure they don't fall under that category and whether they're immune or not.
Okay. Just 1 second. I will. Yeah, no, there's no. Okay. Yeah. No, there's no immunity for that. Okay. So I think if they're a defined position, then we can name them. Okay. So we'll just.
So what? Can I just ask? In making the application, what are you going to get out of it?
Well, first of all, just this month we'll be making half a dozen applications. So this
okay.
Like we make dozens of applications, if not hundreds a year. So it's personally important.
No, I'm more after like.
No, what I'm saying is, if the practice court coordinator, right now we're experiencing a lot of friction in working with her, and there's been, I think, a lot of deliberate blocking of applications, to put it euphemistically. I think that I don't have enough information to allege that it's personal. I think it may be a decision that they're making based on a business judgment or whatever. But there's been a few decisions that have been made where there was clear prejudice that came out of it, and also there's basically determinations made about the appropriateness of the applications, which are judicial decisions in their proper sense. And I can understand if someone makes an application and there's a problem, ultimately they get the right process and they are on their way. But because we're dealing with a lot of applications, the inefficiencies add up, and it creates a lot of issues for us if we have to fight our way through each application. So that's one major issue, and then the other is that I think we have some responsibility in terms of fixing issues if they're identified, because not everybody can identify them or fix them. So
okay. Now, I will just say to you that you should also have a look at the Supreme Court Act and have a look at 24F. And so that will sort of tell you who you should name as a party. Because it tells you here about who's immune and protection from specified court officers. And that includes admin functions.
Yeah, but this is in respect of liability. So, okay, two things. I'd say that it wasn't a good faith performance of duty, because on one occasion we were literally told that we hadn't filed an affidavit of service and therefore the matter cannot be considered, when we had already provided proof of service, which was the email of the other side acknowledging service, and the applications of the other side, they literally had a summons listed, which we were never served. Which, by the way, right now is creating a lot of issues. It's key to orders. And Judicial Registrar Keith was advised that day that summons were not served. He asked the barrister to confirm. The barrister said he's going to seek instructions, and then didn't get back to anybody during the hearing. I kept pointing out that wasn't served. It turned out, so after the hearing, they served us the summons for the first time. And meanwhile, Judicial Registrar Keith basically made the orders on the basis that, after the hearing, you can have a look at the summons, then see if the orders make sense. If they don't, then you can apply for them to be amended. I mean, it's just a mockery of the whole system. But there's clearly, double standards that have been applied. And so I don't think that it was a good faith performance of duty. It's the first thing. But secondly...
Okay, well, in that case, the act is quite clear. If you don't believe... let me finish. If you don't believe it's not in good faith, and if you believe that she has breached her duties or anything like that, well, then you may make an application to judiciary review her. But as I said, it makes it clear here that the Prothonotary cannot be named, and a deputy Prothonotary. So that answers your initial question about who would be named in the proceeding. Yeah.
Can I say, though, I think immunities don't apply in respect of judicial review. They apply in respect of, tort law claims where you're seeking damages against someone. So, it's the same thing with magistrates. They have immunity with respect to claims made against them. But judicial review is a separate thing. You can't have immunity in respect of that. Judges of the Supreme Court cannot be judicially reviewed because the only tribunal members can be judicially reviewed. So that's what I meant when I shouldn't have said immunity earlier because it means something else. But what I meant was only Superior Court judges are, they cannot be reviewed judicially, their decisions rather. But the administrative officers, all of their decisions can be reviewed. So the immunity provision would not apply to judicial review.
Okay.
Just like with the magistrates, you can review, and they have immunity in the same sense. So.
Yeah, well, that's up to you, as I said. So if you want to make that application, that's fine. You can make that application.
So then, would it be? But the court coordinator is not named office here in the 24.
What do you mean, sorry?
In 24F, there are offices that are named.
That's right, And so obviously it's only what falls under our side of the court, should I say, are Prothonotary registrars, deputy registrars, deputy Prothonotaries, and a deputy cost registrar for the rest of probate, so they're not us. So yes, so obviously she didn't make the decision, but she was the person in between, so she was the middleman in her role as the practice court coordinator. So if that's not named there, if that's the person you want to name, that's fine, you can make that application.
Okay, all right.
I can't tell you whether you have legal standing to make the application. I'm just saying that looking at this, if you want to make that application, the court will assess it. Just like we normally would when you were to file any proceedings.
Okay, so a judge will need to assess it.
Well, you wouldn't make if it's a judicial review proceeding, you'd file it the way you would normally would, or turn it on request, pay the required fees, all that sort of stuff.
We're going to add them to the proceeding in the Court of Appeal.
Okay, yep, no, that's fine. If you want to, you need to seek leave to amend the originating motion to add them to the proceeding, obviously, then.
No, we're starting an appeal of Justice Forbes' order.
Okay, and you want to add. So how are you going to judicially review someone and appeal all at the same time?
Because there's a provision in the Supreme Court Act that says that when you apply for an appeal, the court can consider all matters that the Supreme Court could have considered in relation to the proceedings. So any ancillary matters that are
okay, well, yeah, I'm not up to date on all of Court of Appeal proceedings, so all their processes. I'm sorry, I'm not the best person to talk to about Court of Appeal. So if you say there's a provision that allows you to both appeal a judge's order and do a judicial review of another person all at the same time, that's up to you if you think there's provisions to do that.
Yeah, I mean, it could be in the form of a declaration or something of that sort, that the particular decision was made, in jurisdictional error or something of that sort. So
okay, that's up to you if you believe you can do it all in the same proceeding. That's up to you to file that.
Okay, all right. So thank you for that. I will wait for the orders of the update in respect of the freedom of information.
Yep, I'll follow that up for you this afternoon after my lunch.
Yeah, and do you know if the courts are so in the application I had joined the queries that I had for the various courts. Do you know if that was an issue or?
Look, I believe it's mentioned the court services as a whole, so they would be managing all the freedom of information requests as one as a whole. I believe that's what would be happening.
That's okay.
But until I get an update, I won't know anything more at this stage.
Okay. Thank you, Natasha. Cheers.
No worries.
Bye.
Bye.